We're live now. We'll start in another minute.
Hello all. A very good morning, good afternoon and good evening to all the attendees who have joined the KFCRI webinar series from different parts of the world. My name is Shahrukh Kumar. I'm from the Managing Committee of KFCRI. So I take privilege in welcoming you all to this wonderful session of KFCRI's webinar series on the topic, the rise of hybrid dispute mechanisms, Med-Arb and Arb-Med-Arb. So we have with us today Mr. Ramesh Selvaraj, who is the lead panelist for the day. He'll be enlightening us on the hybrid dispute mechanisms. And the moderator for the day is Mr. Syed Mahathir, who is the Research Associate of KFCRI. And also we have with us Mr. V.Inbavijayan, who is the project advisor of KFCRI and the backbone of KFCRI. So I would like to introduce KFCRI to the attendees who have joined this webinar from all over the world. Kovise Foundation Conflict Resolution International is an ADR institution and an accrediting body based out of Chennai, India. So, being an ADR institution, KFCRI has its own tailor-made arbitration rules, mediation, conciliation, and negotiation rules. And we also provide guidelines for tribunal secretaries. KFCRI also takes up the role of appointing authority of arbitrators in many arbitration cases. So apart from being an ADR institution, KFCRI also acts as an accrediting body and a training body. So we provide trainings to practitioners, students, and professionals from various fields in the ADR arena in arbitration, mediation, and conciliation at different levels like associate, affiliate, and fellow. So apart from trainings, we also provide membership under exemption category to pioneers who have already been involved in the ADR practice over many years. So for further details regarding membership and accreditation at KFCRI, you can visit www.kfcri.org. So next, moving on to the housekeeping rules for today. So today's webinar session will be a 1-hour session. The first 40 to 45 minutes will be interaction between the lead panelist and the moderator, and we'll reserve the last 10 to 15 minutes for answering the questions from all the attendees. The attendees can post your questions in the Q&A box below. We request you to kindly refrain from using the chat box to post your questions. If you have any technical difficulties regarding our audio or video, you can inform us through the chat box. We'll try to answer as much as possible of your questions. In case if any of the questions go unanswered, you can reach us through kfcri.adr@gmail.com. So without much delay, I would like to request Mr. Inbavijayan to inaugurate the session by welcoming the speaker.
Thank you. Welcome, Mr. Ramesh. It is a privilege to conduct this webinar on the topic, the rise of hybrid dispute mechanisms, that is Med-Arb as well as Arb-Med-Arb. Today's lead panelist, Mr. Ramesh Selvaraj, is the co-deputy head of the international arbitration practice, as well as he is a recruitment partner at Allen and Gledhill. Obviously, many people after hearing this, they'll be happy that immediately there will be a request for internship. I think hopefully Ramesh would take it and facilitate those. His expertise lies in advising across the broad spectrum of contentious work, not only in Singapore, but across the Far East as well as Southeast Asian countries. He is a fellow of Singapore Institute of Arbitrators, and he is also accredited as a Principal Mediator in the Singapore Mediation Centre. To add on, he is also presently the co-chair of YSIAC Committee. Interestingly, the topic what he has chosen today to share with all of us is really a hybrid one. Even though we have the concept of Arb-Med-Arb in the various legislation, arbitration legislation, as well as the unsettled model law. I think the model law Article 30 highlight about settlement in an arbitration. That's what he is going to specifically explain, the concept of Arb-Med-Arb. Interestingly, he's focusing on the very interesting prior aspect, that is Med-Arb. We should not rush to arbitration. That is what I think Ramesh is going to share with all of you. And he's a perfect person to share because he is not only an arbitrator, he is also a mediator accredited to the Singapore Mediation Centre, which is a pioneer in mediation in our region. Welcome, Mr. Ramesh.
Thank you, Inba, for the very warm welcome.
Yes, Mahathir.
I would like to take a minute to welcome everyone who is joining us through Zoom and through Facebook Live. Welcome, guys. And a special thanks to Mr. Ramesh Selvaraj for being with us today here. So the session is intended to be an interactive one. So I request the participants also to please leave your questions in the Q&A box below. I have prepared a set of questions that I'll be posting to Mr. Ramesh Selvaraj, and after which your questions will be addressed. So without further delay, Mr. Ramesh Selvaraj, can we proceed to the questions that you framed? Sure. So talking about the topic hybrid dispute mechanisms, my first question would be, can you tell us briefly what hybrid dispute resolutions are? And is this mechanism new to the global scene?
Okay, so when we talk about dispute resolution mechanisms and clauses, I think most of us will be familiar with, for instance, arbitration clauses. I think we have encountered arbitration clauses in a contract. We might have also typically encountered what is known as clauses providing for local court litigation. So it could be the Indian courts, the Singapore courts. Those are the standard dispute resolution clauses or mechanisms that we may have encountered. Now, when we talk about hybrid dispute resolution mechanisms, we're talking about combining different modes and types of dispute resolution mechanisms. So when we say hybrid, it typically involves mixing what I would call an adjudicative mode. Adjudicative, for instance, arbitration, litigation, where you're getting an adjudicator or a judge, an arbitrator to adjudicate a matter. Mixing the adjudicative mode with what is known as the non-adjudicative mode. So for instance, concepts like negotiation, mediation, those are non-adjudicative. You don't have a judge or an arbitrator deciding the matter. It is a facilitative process. Parties are leading the discussions to try and problem solve. So that's non-adjudicative. So when we say hybrid dispute resolution mechanism, it's a bit of a mixture of the non-adjudicative mode of dispute resolution together with the adjudicative mode. And typically it happens as part of a tiered process. So for instance, you might start off with the non-adjudicative process, negotiations, mediations first. And if a matter is resolved at that stage, great. If it doesn't, then it goes on to the next stage, the adjudicative process, which may well be court litigation or arbitration. So in that sense, it's tiered, it's a hybrid process as such.
Yeah. So is this something new to the global scenes? To answer my second question, this hybrid mechanism.
It's an interesting question you ask. Is it new? Per se, I think my short answer to that would be it's not new. It is now being formalized as a distinct process, a tiered process. You are seeing tiered dispute resolution clauses in contracts these days, but it's not new in the sense that this idea of mixing the modes of dispute resolution, that's been around for a long time. If you look at civil law countries, for instance, Germany, Switzerland, for instance, it's been very common there for a long time now for arbitrators when they are sitting as arbitrators in an arbitration hearing or in arbitration matter to start off by trying to facilitate settlement between the parties before they go to the arbitration hearing. So that's part of their culture. It's not frowned upon. It's actually welcomed in the civil law world. And I've given 2 examples, Germany and Switzerland, where that happens. So it's not new there. Even in the common law world, for instance, Singapore, where I come from, it's not new either, this mixing of the modes. In the Singapore courts, for instance, I can tell you, if you are going through Singapore court litigation, there is a very early on in those proceedings, in the court proceedings, the court tends to encourage parties to give mediation a shot. So in a sense, the court proceedings would sort of be slowed down somewhat to allow parties to go to mediation separately to try and see if they can resolve matters. And if a party tries to be unreasonable about things and chooses not to participate in mediation, there is a framework within our rules of court for court litigation where parties can be penalized, for instance. Cost orders can be made against parties who unreasonably say no to mediation. So the point I'm making is this idea of hybrid dispute resolution is new in a sense that you are seeing it being formalized as a process now increasingly, but the idea, the concept of mixing has been around for a long time now.
Having said that, broadly speaking, how are such clauses or mechanisms beneficial?
Okay, so how are these clauses beneficial? I mean, first of all, I will say that it's cost effective. I know off the bat, you're probably thinking, how is it cost effective when you are adding another layer as such? But I'd say take a step back. The reason why I say it may well be cost effective is, let's look at arbitration, for instance. When arbitration first started, it was sold as an alternative way to resolving disputes, taking matters away from the courts, where it was believed to take a long time before you got a judgment and so on. So arbitration was seen like as a new way of resolving disputes, a quicker way, a more cost-effective way, confidential way of resolving matters. So that was how arbitration kicked off. But I can tell you, quite frankly, over time, arbitration has gone down the route of becoming more and more like litigation as well. So in terms of the process involved in arbitration, it's starting to mirror and mimic a lot of litigation type processes. As a result of that, it's also tended to be at times lengthy and costly as well. So with that, naturally people have started to find other ways of trying to resolve disputes, and hybrid dispute resolution clauses are an example of disputants being creative. So for instance, if you have a additional layer now, mediation coming in at the first stage, you have an opportunity of accessing a less costly, a more flexible process, mediation, first off. So if you've got a dispute and you know that you've signed up to a tiered process with your contracting party on the other side, you will know that because the first step is mediation, for instance, there's a good chance that if parties go about it and go at the mediation with good faith, you might very well settle. In which case, there's no need to invoke the second step of the tiered process as such. So if parties go about it in good faith, I think there is a real cost saving. So that's one benefit as such that I would highlight. The other thing I would highlight is sort of related to this first point is this concept of preserving the relationship between the disputing parties. Mm-hmm. When you bring in non-adjudicative methods like mediation, for instance, at its heart, non-adjudicative methods basically take out a third-party adjudicator. So you don't have a judge deciding the matter. You're basically telling both parties, the power is in your hands to decide how you want this dispute resolved. The mediator that comes in the non-adjudicative process typically facilitates the process. He's not deciding who's right, who's wrong. He's not deciding the merits of the dispute. He is helping parties to look at their underlying positions, identify their underlying interests to try and help them reach some kind of a solution. And in doing so, one advantage is you can reach solutions and obtain reliefs or remedies that you may not get in court, for instance. So if you went through court litigation, judges apply the law and they can only give reliefs that are available at law. Now, the non-adjudicative methods allow for parties to arrive at solutions which they may not be able to avail themselves of in court litigation, but can do so in the mediation process. So the point I'm making is, because of that, there is a real prospect of trying to preserve the relationship between the parties through this hybrid mechanism. The non-adjudicative process basically allows solutions to be arrived at which is satisfactory to both parties as such. In arbitration or in court litigation, you almost certainly have a winner or a loser. If you go through the hybrid mechanism and are able to resolve matters early on using the non-adjudicative methods, then what you are essentially arriving at is a solution which is satisfactory to both parties. So you don't have a winner or a loser. The advantage there is you've gotten the opportunity or the benefit of trying to preserve the relationship between the parties. So that's something to bear in mind, particularly if the disputants are in the business of trade, for instance. There's an ongoing business relationship. That's a real benefit if you give hybrid dispute resolution clauses a shot. So that's the second thing I think I would highlight. So cost effectiveness, as well as the possibility of preserving ongoing business relationships. The last thing I would highlight is this idea of enforceability. Now, combining mediation, for instance, with arbitration gives parties the ability to improve chances of enforceability. So let me explain. So for instance, if you've got a tiered resolution clause and you go through mediation and are able to resolve a matter, so you've got a mediation agreement which is signed by the parties, there may be some questions as to whether or not that sort of an agreement can be enforced. With this tiered process, you have the option of converting your mediated settlement agreement into an award, an arbitration judgment as such, which then can be widely enforced as such. So there's a real benefit in enforceability in that regard. I think we'll be talking more about the New York Convention later on and the benefit of that convention, the widespread ability to recognize and enforce arbitration awards. So the tiered process gives you that benefit. Mediation settlements can be converted into awards, which can be widely enforced. The one thing I would point out also that I think all of us need to be aware of is that, like the New York Convention, quite recently there's been an entry into another convention, which is known coincidentally as the Singapore Convention, and that's the UNCITRAL International Convention relating to settlement agreements, basically. That's a new convention that has come about. Parties are in the process, countries, states are in the process of signing up to that convention. With widespread ratification of that convention, you possibly are going to be able to, in time to come, also enforce mediated settlement agreements without the need to even go to arbitration as such. So in time to come, it may well be that mediation in itself you're going to see the rise of mediation, because there will now be a prospect of enforcing mediated settlement agreements through the Singapore Convention, and there is no need to convert it into an arbitration award and then have it enforced under the framework of the New York Convention as such. So if I can summarize, broadly speaking, I would say benefits of these type of mechanisms, hybrid mechanisms: cost effectiveness, the possibility of preserving business relationships, and finally improving prospects of enforceability as well. I think those three I would highlight as such.
Yeah, so thank you for answering that for us. So when we talk about hybrid mechanisms, there's a very common question which comes up, which I would like to ask you. Which dispute resolutions come first? Is it mediation or arbitration? Who comes first?
Okay, a good question. Okay, at the heart of it, the key word is party autonomy. So it really boils down to what is parties' intention, what is it that they had decided when they crafted the relevant dispute resolution clause in the underlying contract between themselves. It really depends on how it is framed. So the more common one tends to be mediation first, the non-adjudicative mode, as I said, before you go into arbitration. But the other way around, arbitration first before mediation, is not uncommon as well. So to give you an example, it may be that parties go through the substantive arbitration. The arbitrator issues what is known as a sealed award, meaning he's got an award, but he doesn't show it to the parties. He then double hats, he changes hat to mediator. He goes to try to help parties resolve without actually telling them what the decision might well be, but try to guide them towards a resolution as such as well. So it really depends, to answer your question, it really depends, but it tends to be a scale that is moving upwards, meaning you start with the non-adjudicative and then gradually go up to the ultimate adjudicative process, which is meant to be binding on parties. So it's not uncommon even, for instance, to start with negotiations first, for instance. You start with negotiations between the principals, the business owners, for instance, first, before you go to mediation. And then at a later stage, you could go to arbitration, for instance.
Okay. So having said that, it's become quite obvious that the person is playing dual roles in this kind of dispute hybrid mechanisms. A person is, expected to play dual roles. So what are the challenges that are faced when a person is going through dual roles of mediation as well as arbitration?
Okay, so when you talk about dual roles, you're talking about a situation of double hatting, as I said. I mentioned earlier, when, for instance, you've got an arbitrator wearing the hat of a mediator as well. And if the mediation is not successful, then he goes back to wearing the hat of arbitrator and so on. Now, that has proven to have provoked some controversy amongst various schools of thoughts. Is it ideal? I mean, I have my own views on that.
Sure.
There are challenges, for instance. I give you an example. If I'm sitting as an arbitrator and it's an Med-Arb protocol, we then transition into mediation, for instance. I'm talking to the parties privately, one party, for instance, privately, and they share with me something which is confidential, which has a direct impact on the outcome of the case, right?
Yeah.
The matter is not settled. I then wear my arbitrator hat and I'm supposed to decide the matter, but I would have had some insight on some issues which may subconsciously affect my perception of the matter. It may have a bearing on the outcome of the case as well. These are potential issues, and but these things can be circumvented, can be dealt with by proper thought being given to how the tiered process is crafted. So, for instance, a lot of people don't actually give this much thought, but I think it's very important if you're going to embark on this tiered process that at the time of crafting, for instance, your contract, or when the dispute has arisen between the parties, that parties agree the proper terms of reference, the framework as to how this is going to work. For instance, if the arbitrator is going to double hat, how is it going to work? If he gets access to confidential information, is it an agreement between the parties that will be shared between the parties? These are things that you need to think about early on and work out clear terms of reference so that there is no issue subsequently. Because in the example that I've given you, for instance, that may very well be a ground for trying to challenge the award ultimately. When the award is released by the arbitrator, it may be that the party that shared the confidential information and lost ultimately takes the view that there was some sort of bias on the part of the arbitrator as well. But that can be overcome if proper terms of reference were set out right at the onset, making clear what the arbitrator can or cannot do. Now, the other thing, obviously, is to just avoid double hatting altogether. So even if it's a Arb-Med-Arb protocol, you could still have the option of using a completely neutral party to serve as a mediator. And if the mediation is not successful, you then come back to the original arbitrator, and there's no tainting in that sense, because both parties, meaning the arbitrator and mediator, are kept completely apart in that sense.
So I'd like to talk more about the Arb-Med-Arb process. What exactly does it entail?
Okay, so basically, when parties have agreed to an Arb-Med-Arb process, what that means is, off the bat, when there's a dispute, parties are agreeing that you need to commence arbitration first. So, for those of you that will be familiar, it means you have to file a notice of arbitration, serve it on the other party will put in a response to the notice of arbitration. Typically what happens is, remember, as I said earlier, you need to always go back to the underlying clause which framed the Arb process to obtain guidance as to what needs to be done. What I'm talking about is, in general terms, this is typically how it is framed. So usually you commence the arbitration, and the arbitration is after that state to allow parties to have an opportunity to try and mediate the matter. So it could be that it is the same arbitrator that mediates it. It could be that it is another external party that serves as a mediator to try and help parties. And if there's a resolution, then the arbitration phase is invoked again, and the terms of the settlement are recorded as a consent award between the parties. Now, there are some permutations that could play up as well. It may be that some issues are settled in mediation, some issues aren't. So it may be that there's a settlement agreement reached on some issues, a consent award dealing with some of the agreed settled issues. Those that weren't resolved, for instance, could carry on in the third stage to be dealt with in arbitration as well. So there is a lot of flexibility as to how the process can be undertaken, but the devil is in the detail. As I said, you want to make sure very early on you think about the process and the terms of reference and the framework is clearly agreed to by the parties. So I'll give you an example. The Singapore International Arbitration Centre, together with the Singapore International Mediation Centre, for instance, they've come up with a clear wording for a Arb-Med-Arb clause, which you could basically find on their website, which you could take out and plonk it into your contract. Not just that, they also have a protocol that spells out the process, what happens at each stage as well. So if you're a contracting party, if you're not keen on drafting the process out yourself and slipping up if you've missed anything, it's always good to go and look for existing established protocols, clauses that you could adapt, or maybe even just lift and incorporate into your contracts. because the advantage is the terms of reference and the framework that I've been stressing earlier. That would be by reference incorporated into your contract as well.
Yeah. Thank you, Mr. Ramesh. So when we talk about such hybrid dispute mechanisms, why is it that we just take into consideration mediation and arbitration alone? What about the other dispute mechanisms? Why cannot they be incorporated?
Yeah, so as I mentioned earlier, we talk about mediation arbitration because they happen to just be the more common elements. They are more popularly known, and they tend to be the ones that we see very often incorporated into these dispute resolution clauses. But as I mentioned briefly earlier, there are other methods as well. There are things known as expert adjudication, for instance. Those of you in the construction industry and so on, you could opt for other modes. Expert adjudication is one. Negotiation, as I said earlier, a very common hybrid dispute resolution clause that you see is often three-tiered. You start off with negotiations. So negotiations, how is that different from mediation? It's a lot more informal. It happens without a third party facilitating. So a third party mediator, for instance. Negotiations typically tend to happen between the business owners. So for instance, you could find a clause that says from the time a dispute has arisen, within 15 days, the principals of the business will have to meet, or the chief executive officers of the two companies will have to meet at a location to be agreed and try and basically iron out the issues. And if no resolution can be reached, then we move to mediation, where we get a third party to come in and try to help mediate the party between the parties. And if that fails, you then go to commencing a formal arbitration as such. So to answer your question, again, party autonomy, it's really what parties want. My own suggestion is there's no need to be unduly creative about these things. There are some recognized methods of dispute resolution. Negotiations may be one, mediation, expert adjudication, arbitration. My own advice would be to try to stick to those accepted modes. If you want to be creative, that's fine too. But again, the devil is in the detail. You've got to pay attention to how you craft each step or stage of the dispute resolution mechanism to avoid issues subsequently.
Yeah. So my next question would be about, we have spoke about the challenges as such. Which industries or which sector is said to, most benefit from such hybrid clauses? Okay,
so personally, I wouldn't say there is one particular industry or sector that necessarily benefits the most. In my own view, I think it's widely beneficial across various industries and sectors. The one thing I would highlight, though, you recall when we were talking about the benefits and of these type of clauses, one of the things that I had mentioned earlier was the preservation of business relationships. So I think this particularly would be of use to disputants who are mindful of wanting to preserve their business relationships. So trade, for instance, where there's ongoing trade, recurring trade between a supplier and a customer, for instance. I think those type, particularly, I would imagine would be attracted by these type of dispute resolution clauses, because there's a real benefit to preserving relationships if you undertake or go through this mode of resolution as such.
So what exactly is the attitude of the party when you switch from mediation to arbitration or arbitration to mediation? How do the parties adjust and adapt to it, or what is their attitude towards it?
So the first thing I will say is that increasingly we are seeing that across the globe, I'm not just talking about Singapore or Asia, I think across the globe, there have been surveys that have been done tapping on users, and this is particularly in the field of international commercial disputes. And what the surveys have shown or revealed is that there is an increasing preference amongst users to incorporating non-adjudicative modes of dispute resolution as well to resolve disputes between themselves. And there's a sense that somehow by incorporating these non-adjudicative modes, the commercial dispute resolution in itself becomes a lot more effective. I think the survey statistics are showing this in a big way. You are starting to see a rise in popularity as regards the use of these types of processes to resolve international commercial disputes, for instance. International mediation is becoming a lot more popular as well. And those, I would say, are largely indicative of a change in mindset and how people are looking at wanting to resolve disputes. And I think looking at what we are all facing in the world right now, the COVID situation, I think that's a huge game changer as well. I don't think you are going to see parties necessarily wanting to be embroiled or stuck in litigation or arbitration that is going to be dragging on for 2, 3, 4, 5 years anymore. I think that you will find an increasing need amongst users to want to resolve disputes effectively, quickly, efficiently, and which is why I think the non-adjudicative modes, coupled with the fallback of the adjudicative modes, are going to be increasingly popular. They have been around for a while, have been rising in popularity, but I would be, I'm happy to even say, come out quite bluntly and say, mark my words, you're going to see a huge exponential rise in how these clauses are going to be used moving forward as well.
Yeah. So, with the rising popularity as such, are such missed arbitration awards enforceable internationally? And what is the stand of New York Convention on such hybrid dispute mechanisms?
Okay, so as I said earlier, when we talk about the New York Convention, the New York Convention comes in at the adjudicative stage, right? That pertains to, the New York Convention is a treaty that deals with the promotion, recognition, and enforcement of international commercial arbitration awards. How this works with hybrid dispute resolution clauses, as I said earlier, is if you've settled something with the other side, the terms of the settlement can be converted into an award by consent between the parties, signed off by the arbitrator, issued as a consent award. The ancestral model law, and I think Mr. Inba mentioned it earlier, I believe it's Article 30 or 31, I can't recall, actually expressly recognizes consent awards. So what that means is if you've gone through this hybrid process, mediated, settled, you've got it converted into an award, at least you know that your chances of enforcing this globally, given the reach of the New York Convention, is a good one. I mean, right now, I think there are more than 150 or 160 countries that have signed up to the New York Convention, which means they have to give effect to the convention. They have to recognize foreign international awards. So there's a real advantage there. But in time to come, as I said, things will also be further improved when you start seeing more and more countries signing the Singapore Convention as well. It's called the Singapore Convention because the convention was inaugurated in Singapore as such. But that's also going to provide another leg to stand on. You're going to be able to enforce mediated settlement agreements in the context of international agreements globally as well. So I think there should be little concern over the enforceability of these type of clauses. They are here to stay. They are going to become a lot more popular moving forward as well.
So I have a circumstantial question for you if you don't mind answering it.
Sure.
Yeah. So what happens in a circumstance, the case changes that it's no longer possible or practical to proceed and give to their each tier of dispute resolution clauses? For instance, Med-Arb, can parties avoid mediation and go directly to arbitration instead?
Okay, so if I understand your question correctly, you're talking about a situation where, for instance, in the underlying contract between the parties, parties had already clearly agreed to a tiered process, where
exactly.
it was agreed that you would have to go through mediation first.
Yeah.
And then if mediation fails, you then go to arbitration. If I understood your question correctly, your point was that, look, if circumstances change, could we say, sorry, let's not do mediation, let's just go straight to arbitration? Is that correct?
Yeah, exactly, you've got it.
Okay, so I think the short answer to that is yes, you can. And the answer lies in this concept of party autonomy. Again, as I said, autonomy in the sense that it's parties' freedom to decide how they want to resolve their disputes. That's the very basis on which how the initial tiered process was agreed to between the parties. If parties then subsequently agree to depart from that, to move away from what was agreed and to go directly into arbitration, that's fine too. But the caveat, the thing to be careful about, is you need to be extremely careful and make sure that you carefully document this consent between the parties. If it's not carefully documented, parties go to arbitration, and the losing party then subsequently tries to challenge the arbitration award on account of the fact that mediation was not attempted in the first instance, then you have a problem. So to answer your question briefly, you can depart from it, but you have to be extremely careful in that you record parties' consent to move away from what was agreed extremely carefully. I think it goes without saying that it should be in writing, perhaps even signed by the parties to acknowledge what is happening. I think that would be safe.
Yep. So that was all with my questions. So we have a lot of Q&As which are going on. We have almost 30 questions. So can we start and answer the questions of the people, the guests who are attending, the participants who are attending here? Yeah. So the first question is from Mr. Shankar. Med-Arb can be considered as a cost-effective process, but what about the AMA protocol? What thoughts do you have in the relation to the cost of issue of AMA protocol?
The cost issue, is it?
Yeah, the cost issue.
Okay. It is if you ask me, it is striking a balance more than anything else. There's a slight cost that you incur by invoking that protocol because you get the benefit of the process. The framework, the terms of reference are already pre-crafted for you in that sense. It gives you that clarity as to how the tiered process is to be undertaken. So the costs that is associated with that protocol, I think is a balance that you strike. I don't think the cost itself is prohibitive to the process. I think it is a balance. That's what I would say. I still think even with the cost that you incur with that protocol, overall, I would still make a case for saying that it is still largely going to be a cost-effective exercise for you, because for the user, if you go about the non-adjudicative steps in good faith properly, it may well be that you avoid the full gamut of an arbitration process and a hearing itself.
Yeah, thank you. The next question is from Mr. Shanmugadev. the question is, the person who has acted as mediator would be able to act as arbitrator as well if mediation is not workable.
Again, as I said, there is no strict prohibition as to that. It clearly boils down to what parties had agreed. If parties had agreed for the mediator to then double hat and wear the role or play the role of arbitrator, then that's fine. But it may be that parties are not comfortable with that, in which case, as I said, the real thinking needs to be done even before the dispute arises. When you're crafting the dispute resolution clause, if you're going to go with a Med-Arb, mediator arbitrator, you've got to think about this issue as well. Can the mediator, am I comfortable with the mediator also playing the role of arbitrator? If I am, then let's make that clear in the clause itself that parties have no objections to, or something along those lines. Strictly speaking, there is no legal impediment. It boils down to parties' agreement. My own view, I would stay clear from the same person playing two different roles. It may be better for a neutral party to play both those two roles as such.
So Mr. Venkatesh asked, what are your perspectives on Indian scenario on Med-Arb?
I personally think the Indian perspective won't be too different from the Singaporean perspective. I think the Asian culture for a long time has adopted non-adjudicative methods as well. I mean, if we go back to the old days in the villages and so on, and I think it's probably still the case when you have the Panchayat, the village headmen trying to facilitate disputes between parties as well. It's something which is ingrained in our culture. It's not something that is new to us. So I think from our Asian, Indian cultural perspective, I think we should be very welcoming of the non-adjudicative methods as well. I'm a strong proponent for the non-adjudicative modes of resolving disputes. Sometimes people criticize me for that because they say it's against my self-interest as a litigator, as an arbitrator. But I think we need to be mindful of the fact that we do this for the end users, the clients. They want a quick solution, they want an effective solution, and it's our duty to ensure that we bring that to them. So to answer the question that was asked, I think our perspectives are aligned. Culturally, I think we already are predisposed to this way of resolving disputes. Even at home as well, when there are disputes between siblings, for instance, as parents, we try and encourage them to resolve this amongst themselves first before they come to the parents, for the parents to then decide who's right, who's wrong. So culturally, it's already ingrained. And so I think we should be largely receptive to this mode of resolving disputes.
Yeah. So I'll take another question. One of the attendees says, after the Singapore Convention comes into effect, the parties may enforce the settlement agreement without even going into arbitration to get it enforced. Does it mean that the Med-Arb will lose its applicability?
I don't think it would lose its applicability. It will continue to have a separate track for itself. There will still be users that prefer the arbitration route of things. There's still users that would very much want the fallback of arbitration in the event mediation proves to be unsuccessful. So I think it will coexist nicely. But I do think with the mediation convention receiving widespread ratification amongst states, it will become a force in itself, in that it will be a powerful separate track for parties to resolve disputes without even having to go to arbitration as such. So I think the question is a fair one. I do think that the arbitration track together with mediation will still coexist separately as well.
So we'll go for another question from Shruti Sharma. Where is the stage of conciliation in alternative dispute resolution system? Can you please highlight the thin line of difference between the stages?
Sorry, his question was in relation to conciliation, is it?
Yeah, yeah.
Okay, so I think we spoke about conciliation, or rather we spoke about negotiations earlier. I hadn't mentioned conciliation. Again, these concepts vary. Conciliation itself, I mean, how parties approach conciliation really varies from jurisdiction to jurisdiction. In some jurisdictions, conciliation does not contemplate a third party being involved. Some jurisdictions actually bring into play someone known as a conciliator that comes in to conciliate between the parties. The question is framed very well in the sense that the person who's asked the question talked about how there's a fine line. So if you look at conciliation involving a conciliator, for instance, it's a fine line between that and mediation. That said, I would say that with mediation being the more popular method of resolving disputes, there has been some international custom and practice as to how mediations are to be conducted. So those of you that are familiar with the mediation process will know, for instance, there is this concept of a private caucus where the mediator speaks a party privately and then has another private caucus with the other party. They then have a joint meeting. So there's a lot of literature and custom as to how the mediation process is to be conducted. Different types of mediations as well, evaluative mediations, where the mediator could perhaps give his views on the merits of the matter. Facilitative mediation, where he doesn't give his views, but is just basically trying to bring parties closer and closer together. Conciliation, on the other hand, is a lot more informal as such. It is really for the conciliator to run the process as he or she deems fit, to try and get parties to a resolution as such. So in a sense, he's also playing the role of a facilitator, but with a lot less custom and practice behind him as such. So there is a fine line, yes. Not uncommon to see conciliation as a sort of a stage before mediation as well. Not uncommon. My own advice would be, whilst we are here talking about tiered processes, I think it would also be useful to remind ourselves that we shouldn't try and complicate the process by working in too many stages as well. So you don't want a situation where you're looking at a dispute resolution clause, which has stage 1 negotiation, stage 2 conciliation, stage 3 mediation, stage 4 arbitration. You don't want something as complicated as that as well. So a lot of thought goes into how you want the process to unfold very early on when you are, as I said, crafting the contract, or at the very least once the dispute has arisen between the parties.
One of our attendees asked whether multi-tier dispute resolution model is suitable for all types of disputes in all times.
That's a good question. Is it suitable across the board? That's really the question is being asked. I mean, my own view is I think it is, but I can think of certain situations where some parties may not be too keen on mediation, for instance. Some parties may be of the view that they want an enforceable award at the end of the day, and therefore go through the mediation process just as a matter of course more than anything else. So they don't go at it in good faith. They go through the motions just to tick off on the boxes to say, I've complied with the necessary step of mediation, but I'm not going to agree to anything in mediation. I'm just going to take it to arbitration and I want an adjudicated award. So it really depends on mindsets. My own view is, I think, broadly speaking, it's well applicable to to all industries in all circumstances and situations. But it may be that once you've agreed the tiered stages, as I think, Syed, the question that you raised earlier, when the dispute eventually arises, there may be time exigencies such that there may be no time to go through mediation as such. It's open for parties to, at that stage, relook the tiered clause and see if some agreement can be reached to avoid mediation altogether and for parties to jump straight into perhaps even an expedited arbitration process. But I think as a default, it's not a bad thing to have across all sectors and industries as well.
Yeah. So we are actually running short of time, but we have too many questions. I'm sorry to all the attendees that we'll not be able to address all your questions, but you can definitely mail them to KFCRI team and they will like to address it. They'll definitely address it. I would pass it on to Mr. V.Inbavijayan to take over. Thank you.
Thank you, Syed. Ramesh, it was really interesting. I think a lot of the questions were also really hybrid, and the way the points were highlighted about the hybrid dispute mechanisms were really interesting. One interesting thing I think I could see in the Q&A, which I think Syed, because of the paucity of time, he couldn't raise, but if it's possible for a minute, I think we can discuss. There was a question pertaining to dispute board. I think the dispute adjudication board or the dispute review boards. Whether this is also considered to be one of the hybrid dispute mechanism, even though the dispute boards gives only recommendations. It's not a decisions what they are giving, or it's not a settlement. Can it be treated as a dispute mechanism or a hybrid dispute mechanism?
I think it can certainly be worked. Again, as I said, there's no real magic to this. The key is party autonomy. So it may be that in the case of a dispute board actually making recommendations or sharing their preliminary views on the outcome, potential outcome of a matter, that may be worked in as a lead up to mediation, for instance. So for instance, if you've gotten an indication from the board as to likely outcome, that may then help with how the mediation is undertaken, because it might help with how a resolution might be reached. So one party, the party that has gotten a favorable recommendation may go to the mediation and say, look, I've gotten this, I think you should settle favorably in my favor. The other party can say, look, I don't think that the board has considered all of this. I'm prepared to go to arbitration to ventilate this out. And I do think there are some flaws in the considerations of the board. So it may make for some meaningful headway in the mediation as such. So to answer your question, can it be a step or a stage? Answer is a clear one. Yes, it can be.
That means it's one more addition to the hybrid dispute mechanisms.
It can be.
Very interesting. Okay, thank you, Ramesh. It was really an eye-opener for many people about this Med-Arb as well as Arb-Med-Arb. Now there is also concept Med-Arb-Med-Arb. That also can be added. Anyway, good. It's the settlement. What's happening in the arbitration process is a welcome for the parties, particularly the litigants, wherein they can just really experience the fruit of this particular mechanisms. And very interestingly, if you see all these mechanisms, now it has been moving to the transparency part. From confidentiality is moving to transparency. When it comes to mediation, the confidentiality level, I think, even though it is not guided by legislation, the rules and regulations are really, really facilitating this and having a balance between confidentiality and transparency, wherein the disputes are effectively resolved. It was so nice to hear from a person who's considered to be equivalent to Kamal Hassan, the very famous star of South India. And I am happy, and I thank from the entire KFCRI team. I thank Syed for facilitating this particular session. I thank Shahrukh for hosting this, and obviously Ramesh would take this YSIAC. You can also facilitate the YSIAC activities through KFCRI, so that we have many number of law students are there so that it can be effectively reached, because Singapore is the pioneer when it comes to international arbitration or facilitating institutional arbitration. That has to reach the entire Asian region, as well as more particularly the Indian subcontinent. Thank you. Wholehearted thanks from KFCRI. Now I request Shahrukh to further proceed.
So first of all, my heartfelt thanks to Mr. Ramesh Selvaraj for giving an insight about hybrid dispute mechanisms. I guess the session was very interactive and it was very brainstorming. We had many new facts which were shared from your expertise in this arena. And moving on to a bit of logistics, as I already explained, KFCRI has been taking up trainings in the field of ADR. So as a first step towards KFCRI's online training, we have planned to conduct the first associated arbitration practice online program on 7th of June. I'll be sharing the flyer for the session. So if you have any queries regarding this course, which is to be conducted online, you can write to us at kfcri.adr@gmail.com, and you can also register for this course in the official website of KFCRI, that is www.kfcri.org. And you can also follow us on other social media platforms, that is Instagram, Facebook, LinkedIn, and YouTube, to get our latest updates regarding the upcoming webinars and upcoming programs. So last but not the least, I would like to thank all the attendees who have been patiently watching this webinar for the past 1 hour. Not only the attendees who have joined us in the Zoom webinar, we have also had many pioneers in the ADR arena who have been watching this webinar in the Facebook Live and have been sharing their views. So my heartfelt thanks and gratitude to all the attendees on behalf of KFCRI, and also thanks to Mr. V.Inbavijayan, who has been the sole reason behind all these activities, and all the KFCRI members who have been working behind the curtains for the success of this.
Thank you. Thank you all.
Thank you.